Charlotte Head, Samuel Corner, Leona Cameo, Fatima Zainab Rajwani, you have each been convicted by a jury of an offence of criminal damage. Samuel Corner, you have also been convicted of an offence of inflicting grievous bodily harm. You are all young people who were of exemplary good character. None of you had any previous convictions. There is extensive evidence of your positive good character. Many witnesses have spoken of your kindness and your selflessness and your caring and compassionate nature. You were each appalled at what was happening in the Middle East, particularly after the 7th of October 2023. You were each convinced that Israel was committing unlawful acts of violence, even genocide, against innocent civilians living in Gaza, including children. You are each completely entitled to hold those beliefs. They are shared by many other people. There were lawful democratic means available to you to express your beliefs and to seek to effect change. You were able to, and you did, take part in lawful protest. At least one of you wrote to your Member of Parliament. You could have sought a ruling from the court to prevent the export of weapons to Israel, as others did. But you were dissatisfied and disillusioned with the prospect that anything might change by lawful democratic means. So instead, you decided to take the law into your own hands. Palestine Action was a group that had existed since 2020. Its overarching aim was to shut down a company that supplied weapons to Israel, Elbit Systems, and to end what it regarded as over a century of, quotes, British complicity in an apartheid occupation of Palestine. The strategy to achieve that aim was to carry out actions against Elbit Systems and businesses linked to it in order to intimidate it and its employees from ceasing operations or to cause the government to prevent it from operating. By 2024, Palestine Action had carried out dozens of actions. The actions comprised unlawful activities that ran from what were described as low-level actions, such as acts of trespass, to high-level actions, such as criminal damage and burglary. There is no evidence that before 2024, any of the actions had involved violence against the person or activities that were capable of constituting terrorism. You each attended a Palestine Action training day. You learned about the aims and strategy of Palestine Action. I'm sure that you shared those aims and signed up to that strategy. I've reached that conclusion on the basis of your defence statements, your evidence at 2 trials, your closing speeches, and your pre-sentence reports. None of you at any stage expressed any qualification to your support for Palestine Action's aims and strategy. You each agreed to take part in an action at Elbit's factory in Filton in Bristol in the early hours of the 6th of August 2024. It was described in the planning document as high-level plus. It was a carefully planned and highly sophisticated attack. The planning took several weeks. You operated within a compartmentalized cell. You used encrypted channels for your communications. You employed aliases. After an initial meeting, you kept your cameras off. And when, shortly before the action, you did meet in person to make final plans, you kept your phones switched off. You did all that to seek to evade law enforcement. Reconnaissance was undertaken. Imagery of the target was studied and was marked up to indicate possible lines of attack. There was imagery of a security guard. A safe house was rented for you to stay at in the 48 hours before the attack. You, Charlotte Head, purchased a prison van which would be used to drive through the perimeter fence and through the shutter of the loading bay. You, Leona Cameo, hired another van for transport. You each gave dishonest accounts as to the intended purpose of the vans. You were each provided with sledgehammers and with a backpack that contained items such as a crowbar, flares, a fire extinguisher filled with paint, and rope to be used for barricading doors. You knew that security guards were likely to be at the premises. Whatever you may have been told, it was at best naive in the extreme to believe that there would be no confrontation. What you did was highly dangerous, including by driving a prison van through the shutter of a loading bay. At the time you entered the premises, you did not intend to strike any of the security guards with the sledgehammers. Once you entered the premises, 3 of you, but not Fatima Zainab Rajwani, confronted security guards armed with your sledgehammers, or in Charlotte Head's case, a lit flare, and advanced aggressively on the guard who was defenceless apart from an umbrella and who had sustained a serious head injury. You screamed at him.
To have lost that feed, but that was from Woolwich Crown Court, the judge giving, he's giving...
You, Samuel Corner, spent several minutes smashing up a disabled toilet with your sledgehammer to try and cause a flood. You swung the sledgehammer twice at Police Constable Buxton when he was defenceless on the floor with his arms outstretched, mercifully only causing a minor injury. But you then swung it twice at Police Sergeant Kate Evans. She was on her knees, seeking to arrest one of your co-defendants. She had her back to you. You raised the sledgehammer above your head. You swung it all the way down so that it struck her on the back. She did not have any chance of seeing or escaping from the blow. Fortunately, she was wearing a stab vest, which dissipated some of the force of the blow. But you could not have known that she was wearing a stab vest. Throughout the case, including today, you have sought to portray Elbit as a criminal company that is intentionally assisting a genocide. It is not for the court to make a political or legal or factual judgment about events in the Middle East or about the role or conduct of Elbit in those events. The court's role in sentencing is defined and limited by legislation passed by Parliament. That requires an assessment of the seriousness of your offending by reference to your culpability in committing the offence and the harm which the offence caused or was intended to cause or might foreseeably have caused, and to consider any aggravating or mitigating factors. The court's role does not involve adjudicating upon the conduct of third parties who are not defendants in the case and whose actions are not the subject of these proceedings. Elbit is not on trial. It is not a party to this case. It would be quite wrong for the court to make findings about its conduct in order to inform an evaluation of the seriousness of your offending. That does not mean that your beliefs and motivations are left out of account. It means that an assessment of your beliefs and motivations does not require the court to judge the conduct of the victim of your offending. At the time of your offence, Palestine Action was not a prescribed terrorist organisation. It was not unlawful to be a member or supporter of Palestine Action. The vast majority of its actions were not capable of satisfying the statutory definition of terrorism. You have not been charged with, prosecuted for, or convicted of any terrorist offence. At the outset of the case and at the request of the prosecution, and after hearing legal argument, I ruled that it appeared that the evidence on the indictment revealed that your alleged conduct of criminal damage had a terrorist connection. As I made clear at the time, that ruling had procedural consequences, but did not have any effect on the trial or sentencing. Legislation prevented the reporting of that ruling. You asked me not to lift the reporting restriction because you were concerned it might cause prejudice. I agreed to your request, even though there was a strong public interest in permitting reporting. I've considered the question of a terrorist connection entirely afresh and without reference to my previous rulings. To decide whether your offence had a terrorist connection, the court must apply the test set out by Parliament. Your offence had a terrorist connection if it involved serious damage to property and was designed to influence a government or intimidate a section of the public, and was for the purpose of advancing a political or ideological cause. That question must be considered separately in respect of each of you, but on the evidence there's no material difference between you. I have already told you that for the reasons that I'll set out more fully in writing, the offence of criminal damage that you each committed had a terrorist connection. You each committed had a terrorist connection. There was serious damage to property. The video and the photographic evidence shows the extent of the damage caused, the means by which the damage was caused, and the time period of more than 20 minutes over which it was caused. It extended to the damage of very many individual items of equipment, as well as a disabled toilet. It was substantial damage to the point of destruction. The evidence shows that well over £1 million was paid out by insurers in respect of the damage. Having seen each of you give evidence and considered all of the material in the case, I do not consider that any of you were seeking to influence the Israeli government. In particular, the fact that you were seeking to destroy weapons that you believed were destined for Israel did not involve an attempt to influence the Israeli government in the sense that is contemplated by the statute. But I am sure that one of your purposes of your offending was to influence the United Kingdom government. A strategic aim of Palestine Action was to end, quotes, British complicity, and you were signed up to that aim. For example, you, Charlotte Head, said in your closing speech that you signed up to do an action with Palestine Action, which was a group that had been trying to end British complicity in war crimes, and that direct action was necessary because the government does not listen when people ask nicely. You, Samuel Corner, said in evidence that you were really interested in Palestine Action and that the institutions you'd been trying to convince to act were mostly just ignoring you. You, Leona Cameo, said in your defence statement that you relied on the fact that the UK was allowing arms exports to Israel and that it was complicit in crimes that Israel was committing. And you, Fatima Zainab Rajwani, said in your closing speech that you were sick of waiting for the government to act. You'd each tried to persuade your university or local authority or the government not to support Israel. You'd become disillusioned with lawful protest, and you decided to engage in criminality. You all well knew that an attack on Elbit was an action taken in the furtherance of Palestine Action's strategic aims. Those aims included putting Elbit out of business, and to do that by carrying out actions which were designed to influence the British government to prevent Elbit from operating. Palestine Action material referred to the potential to target Ministry of Defence offices or other relevant buildings associated with government decision-making, and that one of the most critical aspects of taking action was to apply pressure. Whether or not each of you were aware of that particular document, I am sure that you were each aware and had signed up to the underlying sentiment. I'm also sure that your offending was designed to intimidate those who worked for Elbit and for businesses that were linked to Elbit. That amounts to the intimidation of a section of the public. And I'm also sure that your offending was for the purpose of advancing a political or ideological cause. It was intended to advance your beliefs that Israel's approach to Palestine generally and its military activities in Gaza in particular were wrong, that the UK government should not be permitting the export of weapons to Israel, and that it was legitimate to damage the property of others in the pursuit of that cause. Section 69 of the Sentencing Act requires the court to treat your offending's terrorist connection as an aggravating factor. That means it increases the seriousness of the offence. Parliament has set the maximum sentence for criminal damage as 10 years imprisonment. You each had different roles, but you were all fully signed up to the plan and intended to cause as much damage as you possibly could. Subject to individual mitigation, I do not make any distinction between you in terms of the seriousness of your offending. You each bear exceptionally high culpability for the offence. There was an exceptionally high degree of both planning and premeditation. None of you were the organisers of the action, but you were all closely involved in its planning, and you all had a right of veto at every stage. The offence involved many participants over a long period of time. You were reckless as to whether injury was caused to people, including security guards who might have got in the way or might have been behind the loading bay shutter. You each intended to cause very serious damage to property and to render the factory inoperable for as long as possible. None of the factors that are indicative of only medium or lesser culpability are present. As to harm, this was a factory that you believed to be worth £25 million, and to be Elbit's flagship site, and to be the site of cutting-edge research and development. You intended to cause as much damage as you could, and to put the factory out of operation for as long as you could. The harm that you caused included harm to property, which resulted in an insurance payout of £1.175 million. There were additional security and staffing consequential costs. And although not directly covered by the offence for which you were charged, you also caused damage to the premises themselves. I don't have direct evidence from those who worked at the factory, and I don't take into account some hearsay evidence that has been put before me. But I am sure that at least some of those who worked at the factory will have been distressed and concerned about what had been done to their place of work where they were entitled to feel safe. There was also considerable additional symbolic and societal harm in that you sought to glorify criminality and vigilantism and to lend support to Palestine Action's agenda, which now included terrorism. You wore a uniform of red boiler suits. You video recorded your offending with the intention that the videos would be placed on social media. Charlotte Head and Fatima Zainab Rajwani, you each live-streamed yourselves, saying that you'd broken into the most secure Elbit factory and that, quotes, you have been PAL-actioned and long live the resistance, intifada, intifada now. That was posted to social media in the immediate aftermath of the incident. The harm that you caused and intended to cause, and the harm that your offending might foreseeably have caused, were all exceptionally high. It was well beyond that which is contemplated by the sentencing guideline as a high level of harm. The offence of criminal damage is so serious that neither a fine nor a community sentence can be justified. In each of your cases, I will impose the shortest custodial term that is commensurate with the seriousness of the offence, taking account of aggravating and mitigating features. Because there is a terrorist connection, I must impose a special custodial sentence, which consists of the appropriate custodial term and a further period of 1 year for which you will be subject to licence. The guideline for the custodial term in a high culpability and high harm case starts at 18 months custody, with a range of 6 months to 4 years custody. The top of that bracket is less than half of the 10-year statutory maximum. The exceptional nature of both your culpability and the harm that you intended to cause and did cause is such that a significant upwards adjustment to the starting point is required before considering aggravating and mitigating factors. To apply an adjusted starting point that is within the guideline would be contrary to the interests of justice and contrary to the intention of Parliament expressed through the statutory maximum sentence. I adjust the starting point to 5 years custody before considering aggravating and mitigating features. It's an aggravating factor that the offending had a terrorist connection, but in measuring the increase to the sentence on account of that factor, I take account of the fact that you did not intend to injure any person, that part of your intention in taking action was to prevent the death and suffering of Palestinian civilians, including children. That significantly reduces the extent of the increase in the sentence that would otherwise be appropriate. It is also an aggravating factor that you were on the premises as trespassers. You knew you were not entitled to be there. You used extreme force and aggression to break in, deliberately using a large vehicle as an instrument of destruction, driving the van through 2 security fences and through the shutter of the loading bay. There was a high degree of persistence. You continued when security guards intervened, and as a group you tried to get them to leave. There is a degree of overlap between the aggravating factors and the factors that resulted in an elevation of the starting point. I have therefore been careful not to double count the weight to be ascribed to each factor. Nevertheless, each of the aggravating factors is substantial in its own right. In combination with each other, they are truly exceptional.
That's the judge, Mr. Justice Johnson.
After taking account of the aggravating factors that apply in each case and subject to mitigation, I would impose a sentence of 7 years custody in each of your cases. That is a 2-year increase. In each of your cases, I've taken full account of everything in the materials that have been put before me, including the pre-sentence reports and everything that has been said on your behalf. I followed the applicable Sentencing Council guidelines, including the guidelines on sentencing young people and those with mental disorders or neurological impairment. The fact that you were trying to shut down a company that you thought was acting unlawfully does not reduce the seriousness of the offence. In this country, we all live under the rule of law. That means that the law applies to everyone. Everyone is equal before the law, and everyone is entitled to look to the law to protect them and their property from criminality. The law does not tolerate vigilantism. Elbit is entitled to look to the police and to the courts to protect its property. Those who believe that Elbit is acting unlawfully are not entitled to take the law into their own hands and damage its property. The fact that you did so does not amount to mitigation. Rather, your motivation and the way in which you acted on your motivation is reflected in the aggravating features I have identified. That includes the offence having a terrorist connection, but where the extent of the uplift takes account of all the circumstances. Your offending did not amount to an act of civil disobedience, where conscientious motivation can be treated as mitigation. In such cases, the offenders act with restraint, recognise that their conduct is contrary to the law, and accept the consequences of their actions. You acted with excess, not restraint. You maintained that your conduct was lawful, and you refused to accept the consequences of your actions. I have taken full account of your exceptional positive character. In each of your cases, it is a substantial mitigating feature which will be reflected in a considerable reduction in each of your sentences. I have given it the greatest possible weight in each case. You, Charlotte Head, have struggled with your mental health. It's not suggested that this reduces your culpability for the offence, but it does, I accept, make it likely that custody will be more difficult. You, Leona Cameo, have anxiety, depressive symptoms and trauma-related distress, which again may affect your experience of custody. Again, I do not consider that it reduces your culpability, but I take account of the impact it will have on custody for you. And you, Fatima Zainab Rajwani, were 20 at the time and you're now 21. You were therefore a young adult, but substantially younger than Charlotte Head and Leona Cameo. I've taken account of your age as a mitigating factor. However, your offending was not impulsive or due to peer pressure. It was planned and carefully thought through over several months. You spent a few days thinking about it before signing up to the action. Almost 2 years on and 2 years older, you still appear to believe that you did the right thing. You also have a diagnosis of ADHD, and I take account of the impact that custody will have on you. And you, Samuel Corner, were only a little older, and I agree with the finding in the pre-sentence report that there is a degree of immaturity. But in your case too, I'm sure that your decision to take part in the action was not impulsive or due to pressure, but was planned and carefully thought through. You've been diagnosed with autistic spectrum condition and with ADHD. I do not consider that your age or your conditions reduce your culpability for the offence of criminal damage, but I do recognise that it may make custody more difficult, and I take that into account. Samuel Corner, you also committed an offence of inflicting grievous bodily harm. The statutory maximum sentence is 5 years imprisonment. You bore high culpability for that offence. The victim, Police Sergeant Evans, was, in the circumstances, obviously vulnerable. She was on her knees, facing away from you, trying to do her duty and arrest a co-defendant. You used the sledgehammer. It weighed 3.2 kilograms. You swung it from full height down to her on the ground. You agreed that it is obvious that if you hit a person with the sledgehammer, it's capable of causing really serious injury, including broken bones. I'm sure that it was, in the way it was used, something that at least approached being a highly dangerous weapon. There was a degree of persistence in that you swung the sledgehammer twice, having previously swung it at another officer. I do not accept that this was, in any realistic sense, an attempt to use force in the lawful defence of another person, or that, as you said at the time, you were protecting one of your co-defendants. Sergeant Evans was not using any unnecessary or unlawful force. You'd heard screaming, and your vision may well have been obscured, but you had no reason to believe that it was necessary to attack Sergeant Evans, far less to do so in the way you did. You swung your sledgehammer at her, just as you had swung it at PC Buxton and at a security guard with no justification. This was extreme and gratuitous force against a vulnerable police officer who was acting in the course of her duties. Although the attack on her was short-lived, that was only because of the intervention of other officers, and it came in the context of several minutes of violence towards property and violence towards others. You did not intend to cause really serious injury, but you must have known it was highly likely that Sergeant Evans would suffer serious injury. As it was, she did suffer really serious injury. She sustained multiple fractures to her vertebrae. The injuries have had a substantial and long-term effect on her ability to carry out her normal day-to-day activities and on her ability to work. Almost 2 years later, she has still not been able to return to full operational duties. She's not been able to sustain a role as a sergeant and is unable to work overtime, so she has lost significant earnings. She still experiences disturbed sleep. There's been an effect on her parents and her children, who are now fearful for her safety. The injuries do not fall within the highest category of harm, which involve threat to life or a need for lifelong dependency on others, but they do fall within the next category. The sentencing guideline starting point is 3 years custody, with the range of 2 to 4 years. It is a substantial statutory aggravating factor that the offence was committed against an emergency worker acting in the exercise of her functions as such a worker. The same mitigation applies. In the light of your autism, the noise and smell in the factory may have been overwhelming and may have impaired your ability to exercise appropriate judgment or make rational choices, or to understand the nature and consequences of your actions. And that may explain why the jury were not sure that you intended to cause really serious injury. If so, your autism has already been taken into account in very significantly reducing your culpability. But your autism does not begin to explain why you chose to swing a sledgehammer at a police officer. I do not accept your counsel's suggestion in the written sentencing note that an element of autistic meltdown led to the assault. That was not an explanation that you gave in evidence. Your explanation was that you were acting in the defence of a co-defendant, but that explanation was rejected by the jury. There's no medical evidence to support your counsel's suggestion that autism can explain a decision to swing a sledgehammer at a police officer. I do not accept that your culpability for this offence is reduced by reason of your autism or by your attention deficit hyperactivity disorder. The pre-sentence report suggests that you are remorseful. I do not accept that there is any substantial and genuine remorse. After striking Sergeant Evans, and when it must have been obvious that she was injured and in great pain, your first reaction was to tell her that she bore responsibility for Israel's conduct in Gaza. You declined to answer questions in interview. Nothing in your defence statement acknowledged the harm that Sergeant Evans had been caused. You advanced an unrealistic account that you were acting in self-defence. You refused to accept that her injuries amounted to really serious harm. As Officer Evans says, you have never even said sorry, although your counsel says that is now something you would wish to do. The aggravating factors I've identified substantially outweighs the mitigation and requires a substantial uplift from the 3-year starting point. You fall to be sentenced for 2 separate offences that were committed at the same time. It is necessary to consider whether to impose concurrent or consecutive sentences and to consider adjusting the terms so as to ensure that the resulting total sentence is just and proportionate to the totality of your offending. Although committed at the same time, these were quite distinct against different victims and causing entirely distinct harm. It is appropriate to impose consecutive sentences. I've reduced the sentence I would otherwise have imposed on the criminal damage charge to reflect the principle of totality. I will impose a determinate custodial sentence for the offence of inflicting grievous bodily harm. You will serve between 1/3 and 1/2 of that sentence. I will impose special custodial sentences for the offences of criminal damage. You will each serve 2/3 of the custodial part of those sentences in custody. You will then be considered for release by the parole board. If you are released, you will remain on licence until the end of the custodial term and will then be subject to an additional licence of 1 year. If you are not released at the 2/3 point, you will be released at the end of the custodial term and will then remain on licence for a further year. If you breach any of your licence conditions, you may be recalled to custody. In each case, you'll be subject to the automatic imposition of terrorist notification requirements for a period of 15 years. You will each be credited for the time you have spent remanded in custody pending trial. In the case of each of you, apart from Samuel Corner, there will also be a deduction of 45 days from the sentence to reflect one half of the time you have spent on what was, or at least was intended to be, a qualifying curfew. You, Charlotte Haird, used the prison van to commit the offence. It was integral both to the commission of the offence and to its demonstrative nature. It was not simply used for transport. You also drove it without insurance. In addition to the custodial sentence, and after taking account of the factors in the Sentencing Council guidelines, it is necessary, fair, and proportionate to disqualify you from driving for an effective period of 1 year. Because I'm also imposing a custodial sentence, I'm required by law to extend the period of disqualification by 2/3 of your custodial term so that it has effect after your release. I have decided not to make compensation orders in any of your cases. You are each facing a lengthy custodial sentence. It is not reasonably likely that you would have the means to satisfy any compensation order. The assessment of the amount would not be straightforward. It is open to Elbit and to Police Officer Evans to bring legal proceedings to seek compensation. You must each pay the statutory victim surcharge in the sum of £228 or such other sum as is required by law. Would you each stand up, please? Charlotte Haird, for the offence of criminal damage, I sentence you to a special custodial sentence of 6 years less 45 days. That consists of a custodial term of 4 years and 320 days and a 1-year additional licence. I disqualify you from driving for 4 years and 91 days. Leona Cameo, I sentence you to a special custodial sentence of 6 years less 45 days. That consists of a custodial term of 4 years and 320 days and a 1-year additional licence. Fatima Zainab Rajwani, I sentence you to a special custodial sentence of 5 years and 8 months less 45 days. That comprises a custodial term of 4 years and 200 days and a 1-year additional licence. Samuel Corner, I sentence you to 3 years and 8 months imprisonment for the offence of inflicting grievous bodily harm. For the offence of criminal damage, I sentence you to a consecutive special custodial sentence of 5 years. That comprises a custodial term of 4 years and a 1-year additional licence. The total sentence in your case is therefore 8 years and 8 months. And you may now be taken from the dock.